I chose this title, Carpe Diem, because I wanted to reflect on the fact that we have opportunities, that we need to seize the moment, we need to seize the day, we need to seize those opportunities. During Prof. Caroline's keynote yesterday, you remember that she mentioned priority areas, and one of the issues or one of the aspects that we could then focus on is intellectual property. You've also heard Albert this morning about innovation and about the state of innovation when it comes to AI innovation on the continent. So I wanted something that would help us to reflect on opportunities that we have to leverage on intellectual property as one tool, as it were, to scale AI innovation on the continent. I like this post by Paul Norville on LinkedIn, and he says that there are 3 avenues to opportunities, and he mentions events, trends, and conditions. And if you have opportunities that happen through events, you need to be able to respond. When opportunities happen through trends, you need to make plans. And when opportunities emerge through conditions, you have to act on them. And so I wanted to then highlight some of the events and the trends and the conditions that we see across the continent that we could then leverage on and seize that opportunity to scale AI innovation on the continent. But let's start with a joint, from a place of joint understanding. Next slide. Yeah. Intellectual property is, I think, something that everybody in the room is conversant with. You can't be dealing with CPIT and you don't know what intellectual property is. But I wanted to just refer to some sort of definition just so that we are on the same page for purposes of this conversation. Creations of the mind, inventions, artistic works, literary works, designs, symbols, they are all considered intellectual property. But one of the things with intellectual property is that it's a creation of statutes, right? They are creations of statutes. So it is the law, for example, copyright law, that tells us this is protected, this is not protected, right? It is trademarks law that will tell us that this logo or this brand is protected by trademark law. It tells us for how long, it tells us what someone would do, and they would be infringing on those rights. So there's every reason to come to intellectual property as one way of driving innovation, of promoting innovation when we speak about AI. And then innovation. Albert said he didn't want to start defining innovation, so I said, yeah, I'm going to do that. But innovation is also something that everybody talks about. We need to be innovative. There's innovation happening in Africa. There's innovation. But at the end of the day, right, innovation is about taking an idea from inception to impact. So you're not maintaining the status quo. You're moving from there. You're building, you're growing, right? So even with AI, when we speak of AI innovation, we're also then saying we're not just providing tools and it's done. We continue to reiterate, we continue to build, we continue to improve. We don't just stand where we are and fan ourselves and say, we've achieved greatness, now we can stop. We keep creating, we keep innovating. And that's what we're hoping to see that intellectual property will do for us in the AI space in Africa. So AI, I'm taking the definition from a book that I contributed to, which was edited by Prof. Caroline, Desmond here, and other people. Melissa also contributed a chapter in that book. But AI, powerful algorithms, machines, computer systems that have over time developed human-like capabilities. What is going on? Albert. Albert, Albert was talking about agentic AI today, but also yesterday, and expressing concern about Desmond's view that the way the law is now, agentic AI, where the law is not coming for you yet, because not that the law is not coming for agentic AI, but more that it is not, they are not going to be legal subjects that will be regulated. The only thing I would say, so that I don't deviate from my mission today, is that even when the law decided that companies are going to be considered juristic personalities, considered, people that can be sued and that can sue, you would see that the humans, the directors, the shareholders, the people behind the company would always be held responsible when things go wrong. So you can't sue the company, get money and all that, but if somebody's going to go to jail, it has to be a person. So the person building the agentic AI would need to know what they are doing. Yeah, but anyway, when it comes to AI, intellectual property, innovation, what you then find is that two things. AI can be a tool for innovation. So you could then use AI in the sense that you use it to move from idea to impact, right? So something could be going great, but you could make it greater when you then bring AI into the picture, right? So public service delivery, for example, could be made even more efficient with AI, and that's innovation, right? But there can also be innovation in the way that AI itself is deployed, is designed, is developed, and that's what we want to also see, right? So we think about intellectual property, innovation, AI, Africa. We think about it from those two key perspectives, that AI can be a tool for innovation, and there can also be innovation in the way that AI is designed, developed, deployed. And I think the later part is even very critical for the continent. Why? Because a lot of what we are hearing about taking leadership of AI is focused on the first part, where you're using AI to drive innovation. But I think that Africa has a key moment to actually be a leader in being innovative about the way that AI is designed, about the way the AI is deployed, developed, and all that. Next slide. So when you have these three things, you have IP, you have AI, you have innovation, what you're hoping to see is development, right? So you want to see that at the end of the day, when there's AI innovation going on and you bring intellectual property into the mix, and you have innovation, you want to see development, you want to see the continent move, higher and higher, bigger and bigger, and grow from there. So AI innovation, whichever aspect you're looking at, is data-driven, right? So whether you're thinking about it from an object or subject perspective, you are going to be asking the questions, where is the data from? Where are you getting this data? Whose data is it? What has been created with the data? What has been created from the data? It's always going to be about the data. Because for me, when you think about AI innovation, you're actually thinking about how the data makes it into that AI system and how it drives the way that the AI system operates. So it's always going to be about the data, one way or the other. Link that back to what intellectual property protects: creations of the mind, inventions, brand protection, literary works, artistic works, designs. You think about all that, and then you relate that to what intellectual property, when you think about what intellectual property protects, and you relate that to what happens in the AI system, you start to see patterns. You start to see that there could be protection here. There could be something we could be doing with intellectual property. These are 4 projects of the past and present that sort of reflects the relationship between innovation and intellectual property. The first one is a book project led by some authors from Australia. and it was about what if we could reimagine copyright? What if we could ask ourselves, if we could start on a clean slate with with copyright, what would we change? And the authors were sort of given a blank check to say, if you had the opportunity to start all over with copyright, what would you change? And some people were talking about the duration of copyright and saying, why should copyright last for 50 years after the death of the author? So if the author lives to be 90, then the protection of the work is going to be 140 years. Why should that be the case? It's too long for someone to have exclusive rights to something. Some were thinking about the scope of the exclusive rights and how it could change, how it could be enforced. The authors in that work concluded that some of the ideas would be impossible to achieve. But for purposes of what we are seeing with AI, it's then possible to actually start thinking, should we have intellectual property operate the way that it has always done in the AI space? Is it going to benefit us as Africans, right? And then the other one is also like the reimagined copyright one, where people were looking at the patent system, thinking, again, referring to what Albert was saying, thinking if you had inventions and you were leveraging on AI to arrive at, describe prior art, for example, arrive at, invention quicker than you would ordinarily without AI. What does that say for the patent system? Should we have the same duration? Should we then, should we have a different kind of duration for different kinds of inventions, for example, depending on what we are trying to address? Those are thoughts. And then with the Scaling Innovation project, which is a project by the Open African Innovation Research Network, it was looking at how innovation is actually scaled on the continent, and how does intellectual property contribute to the scaling of innovation. The last one is a WIPO conversations, where WIPO continues to look at frontier technologies and asking questions around IP. So this is Data Science Law Lab, and I brought this up because I wanted to say that those are the kind of questions that we're asking at Data Science Law Lab, not just to take intellectual property at face value, but to look at it from the perspective of how can we use intellectual property to scale AI innovation? So it's not just about saying intellectual property gives you ownership of this, it gives you exclusive rights to this. What about instances where having those exclusive rights does nothing for you? What about instances where it is better to leverage on those exclusive rights to have some bargaining power to sit in the room? And that's one of the things with the Mulito Obodo Open Data License, the Noodle license that I said I was going to pronounce it, that Melissa and I co-developed and worked on. One of the things that drove us to that point was talking to innovators on the field. So working with people like Leo, for example, talking to people like Albert, talking to people like Fukosi, my colleague at the University of Pretoria, to say, to say, what are the challenges you are experiencing collecting data on the field, dealing with communities, and then building these tools? How does it trickle? Should it even be trickling? It should go direct to the communities, right? And they should be getting the benefit of what they contributed to. How is intellectual property, for example, contributing to whether or not they get that? And I now want to go to events, trends, and conditions that we need to respond to. That's the road to using intellectual property to scale AI innovation. We're going to run quickly with this one. So events to respond to. The African Continental Free Trade Agreement is an event, right? It was signed, and it quickly got enough signatures to become effective. There's a protocol on intellectual property. There's also a protocol on digital trade, competition, and all that. How should we factor in AI innovation in the way that the annexes to these protocols are designed. It's an event, it's something, it's an avenue to opportunity that we should be responding to. In South Africa, you have the Constitutional Court being, at least as far as I know, the first court in Africa to deal with copyright exceptions as something that brought people to court. Now it's not that you were sued for copyright infringement and then you are saying exceptions apply. In this case, it was people with visual disabilities that went to court to say, we need a pronouncement that actually admits that the Copyright Act in South Africa is unconstitutional to the extent that it adversely affects the rights of people with visual disabilities. And you can even extend that to then say, what about other disabilities? They are also, included in the later decision of the South African Constitutional Court on the matter, dealing with disability rights jurisprudence. Think about other kinds of disabilities that are not necessarily physical. What about economic disability, where you are actually not able to have access to resources that make sense or that enable you to live a full life or have a quality of life as a human? And as Africans, it's something that we could be thinking about. So that's an event to respond to. Next one. In Nigeria, there was the Copyright Act. That was a new Copyright Act that was passed into law. One of the things with that Copyright Act was that it made mention of fair use as an exception, and it was broad. It's a broad exception that allows, access to data, that allows access to AI innovations that might not ordinarily be possible with the old dispensation. And then we keep hearing AI policies and strategies are being adopted across Africa. It's on the rise, and it will continue to rise. More and more countries will be coming up with their strategy documents. More and more countries will be coming up with their policy documents. Next slide. And so, how have we at Data Science Law Lab, how have I personally responded to these events? This is a paper that I wrote thinking about how should the executive arm of government realize a right to research. So if you have those exceptions in the law, how should we make those exceptions easy for people to work with? If you're waiting for lawsuits to happen, if you're waiting for a situation where somebody will go to court, it might not happen. If it happens, it might take so long that you will not quickly realize the benefits. So we need the executive, right? We need the government to be able to be speaking more also about exceptions, to be saying, this is how these exceptions apply. These are, instances where they apply, and that's what this paper is about. For trends, there's increasing recognition of indigenous rights. More and more, we're recognizing local communities, whether they are geographically bound or whether they are bound by interest. There's rising enforcement of copyright in digital space in the global north, at least. There's more and more lawsuits about people using copyright-protected subject matter to train AI. There's a shift towards open access, open data policies, licensing in research. You hear more and more about responsible AI, ethical AI, inclusive AI. All these are normative values that we should be thinking about when it comes to how we could leverage intellectual property to scale AI innovation. Again, this was a paper that I wrote about copyright and data mining and developing models for South African natural language processing, asking the question of what copyright exceptions can help researchers that are involved in natural language processing be better able to access data for such projects. Next slide. This one was an article that I wrote with Vukosi, my colleague in Department of Computer Science, and it's basically a case study that we're looking at organizations like Masakane, and how they are navigating the challenges of copyright. And it was this paper that actually sort of crystallized some of the challenges with using African language data in building models or in creating data sets. And it was a precursor to the Nudu license. This was also the book chapter I contributed, and that was also then drilling down to looking at intellectual property broadly as more than just exclusive rights, but also looking at it as also from an exceptions perspective and thinking how can we leverage both the exclusive rights and the exceptions that you have in various intellectual property laws to drive AI innovation. Next slide. The conditions that we can act on. There's underdeveloped AI infrastructure. We've talked about that throughout this conference so far. Limited IP enforcement, limited formal IP policy. So what you find is that there's AI policies on the rise, there's AI strategy documents on the rise, but little mention about the way that intellectual property could play in this space. So there's that gap that needs to be addressed. And so I can't end. Just like Albert couldn't resist mentioning M-Pesa, I can't resist not mentioning the Nudu license, because I think that, and I'm not even speaking from a biased perspective, I think that the Nudu license is innovative, right? Because of the way that it addresses openness. So we're not saying that we're not saying that everything should be proprietary when it comes to data and data sets on the continent. Instead, what we're saying is how do we practice openness in a way that recognizes the inequities that are on ground. So if as Africans we are building for ourselves, if as Africans we've realized that no one is coming to save us and we want to save ourselves, we can't then be building and end up not benefiting from what we are building from. And that's what the Nudu license aims to address. And there's also now this policy hackathon that we started last year and we've done every year, where we are looking at emerging technologies and looking at it from the context of Africa and law and thinking what are the policies that can make sense for this space. So seize the opportunity. We need inclusive policy dialogues. We need to audit existing systems. We need to invest in infrastructure. And investment is not always money. It can be other resources. It can be, our talent. It can be in the way that we come together and address the issues of our continent, of our countries. We need to support equitable open access. We need to collaborate regionally and globally. Next slide. So we need to define our own AI IP policy. We need to define the narrative. Data Science Law Lab is already contributing to research in this space. Now is the time to act collaboratively and strategically. An African AI policy should be what? Context-aware, future-ready, inclusive, ethically grounded. It needs to be interoperable and harmonized. We can't be saying different things. It doesn't help us. The reason why you find that sometimes it's difficult to deal with us, as a collective, is that A is saying this, B is saying another thing, and then the people that we are working with will say, how are we going to talk to you guys? You need to be saying, the same thing. We can then drill down to specifics when we get to our individual countries. And what should collaboration look like? We need to co-develop, partner, and scale, together. We can't be, like I said, doing different things. Last slide, I think. So let's shape AI IP governance that protects, empowers, drives innovation together. Thank you. These are collaborators from us. Thank you to them. Last slide. Thank you.